Over to you, sir.
Okay. Good evening, CS Vishwanath Kote sir,
Good evening, sir.
ladies and gentlemen. You are most welcome to the today's session of sensitization of companies regarding provision of Section 90 of Companies Act 2013. Basically, Company Act Section 90 is pertained to when there is a significant beneficial ownership. In that case, there is certain things to be done by the company and certain things needs to be done by the individual. So basically here is something what is the exactly and what all the provision is there. So regarding this, we are having a very today eminent speaker with us who will deliberate on this issue. Today we are having with us CS Vishwanath Kishan Kote sir. Basically he is a BBA from Pune University, completed in 2013. Then he completed DLL and LW in 2015 from ILS of Pune University. He is associate member of company secretary. He is also UGC net qualified in 2022, a registered independent director. Presently he is practicing from last 5 years as company secretary and partner in ATS and associate. He is not only a practicing member but also keen to do teaching work, and many students have been benefited because of this liking. Presently he is working as a faculty for CMA inter student and trained more than 1,000 students in the subject corporate law, ethics and economics. He's having expertise in a startup license and handling compliances of the companies. And very special to this, he is a very good motivational speaker and mentor. With this, I will invite CS Vishwanath Kote sir to take these things and emphasize on the subject. Over to you, sir.
Okay, sir. Thank you, sir, for a detailed introduction. As discussed with Pradeep sir, I was expecting Pradeep sir to introduce me because Pradeep sir is the one who introduced me or connect me with a PCA chapter. As we are already started in a delay, I will start with a presentation. Okay. So topic for the day is a sensitization of companies regarding provision of Section 90 of the Companies Act 2013. Read with SBO Rules 2018. Nowadays, SBO is a trending topic. Section 90 is a trending topic. Provisions are not new because SBO provisions and bend to form, which is the main compliance under Section 90, which is introduced approximately 4 or 5 years ago. In July 2019, first time bend to form was introduced. But in a last week itself, on 27th of October 2023, MC has issued a one important notification, and for that notification, what happened? All the small companies supposed to mandatorily dematerialize their shareholding, all non-small companies. So what is the non-small companies as per the provisions of Companies Act? Small company is a company who has a paid up capital of 4 crore or less than that, and annual turnover of 40 crore and less than that. So all non-small companies supposed to dematerialize the promoter and director shareholding. So as per the notification dated 27 October. So we'll later on look in the details. So let's start. In overview, today, while discussing section 90 in a detail, index will be first we'll understand the importance of the section. Later on, we'll find out the applicability. What are the uh, entities or who are the individuals who are applicable or covered under section 90 and treated as a SBO, who are here we have to find out the SBO. Once we identify the SBO, then we'll look into the compliance. What are the compliance supposed to do? Okay, so in three part we are continuing in a presentation for the better understanding. Also, I have tried majority examples, practical example, so we can have a detailed understanding of the applicability, because applicability is the main focus. Once we identify, we can comply. Compliance is not a big task. Big task is the identification of applicability, because SBO section 90 is one of the tricky sections of the Companies Act. We can compare with other related party like sections. So point is, while discussing the importance, why should we study the SBO provisions, or why the government has introduced the SBO provisions? The first thing is to promote the corporate transparency. Second is, government can control the misuse of corporate vehicle for illicit purposes such as the corruption, tax evasion, money laundering. These kind of activities can be controlled by the SBO compliances. Next one is to close the loop on combating money laundering. Next, to identify the ultimate individual owner. So ultimate thing which pointing out in SBO under section 90 is, we have to find out the who is the ultimate owner of the company. So we will go in detail step by step in next slides. So at a global footprint, whenever Modi ji go in global meetings, so they commit that India will do this much of action. So FATF, Financial Action Task Force, develop a series of recommendations on transparency and beneficial ownership of legal person and arrangement. And the section 90 and latest amendment last week itself notification is the part of the Financial Action Task Force commitment at a global level of India. So we have notification on 27th October 2023 got a substantial changes to the significant beneficial owner compliance landscape. What notification says? Non-small company is supposed to dematerialize compulsorily. What it actually impact while we look in a practical aspect? So what happens normally before this notification, only public unlisted companies supposed to dematerialize their shares. Public unlisted company. From 27th October onwards, by this notification, all private company also who are non-small supposed to comply with the dematerialization as per the Dematerialization Act provisions. Sorry. In addition to the non-small companies, Nidhi company, which previously excluded from the dematerialization applicability, now onwards have covered. So what notification says in short, all the companies who are non-small as on the 31st March of 23 has given a timeline for the dematerialization of their promoters and director shareholding of 18 months. Means due date for dematerialization of promoter and director shareholding for non-small companies as on 31st March 2023 is 30th September 24. We have to dematerialize the securities before 30th September 24 by this notification. Since last 2-3 years or since COVID period, firstly Ben2 form, which is a main form for the compliance of section 90, has introduced in July 19. Later on 2-3 times due date for the submission of Ben2 form or declaration or reporting form of SBO is extended. Later on COVID is coming, but meanwhile government has not lose the strictness on the compliances. Government has raised approximately 2000 plus notices to the respective companies for late filing of the Ben2. What it means, many of the companies are in assumption that let's assume 31st October is the due date, while any company submit the form Ben2 with the ROC before 31st October, that company is supposed to pay regular fees. Let's assume 300 rupees is the regular fees. But if any company paid in a delay after 31st October, he has to pay additional fees. Or what is the interpretation of normal professionals, that we have paid additional fees while paying while submitting a form in a delay, means we have ratified our error or delay of compliance. But it does not mean the same. Government has just given option that you can avail by additional payment of fees. That's it. But it does not mean additional fees will be treated as a payment of penalty. So what are the as per the section 90 sub rule 11, penalties are mentioned that company penalty on company can be levied from minimum 1 lakh to maximum 5 lakh, and per officer in default, who is normally a director of the company, will be minimum 25,000 to maximum 1 lakh penalty. So these kind of lakhs of rupees penalties and notices has been drawn across the country to approximately 2000 or more companies by the government. So we can, being a professional, can have an idea the what are the seriousness, what is the seriousness of the section 90. In response, MC has issued advisory notices to all the companies under section 90. So better understanding what we have to read for the section 9 SBO, we have to read the section 90 of Companies Act 2030 and Rule 9 of the Companies Management and Administration Rule 2014. In addition to that, while notification on 27th October, MC has undertaken the revision of Companies Management and Administration Rules 2014 by introducing the Rule 4 to 8 under Sub Rule 3 in Rule 9. Applicability. Actually, this slide says about the what are the modes or entities where section 90 or SBO provisions are not applicable. So SBO rules, SBO stands for significant beneficial ownership. Rules not applicable to the extent of shares of a reporting company held by IEPF, Investor Education Protection Fund. It's holding reporting company. Point we have to understand here is that reporting word. Just to confirm, am I audible clearly? Just want to confirm.
Yes, sir. You are audible.
Okay. 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 So point to note here is the holding reporting company. Normally, holding company. Let's assume A is the one company, and A company shares are held by the B company. Okay, and B company have an individual shareholder. Let's assume that individual shareholder, Mr. C, who is the individual, is the SBO, significant beneficial owner, who is not that, who has ownership SBO in a company, but his his name is not reflecting in a list of shareholder of a company. So this is the basic criteria. But in case there is a multiple layers of a shareholding, A company, under that other body corporate is a shareholder, under that B company, C is the third body corporate who is a shareholder, and chain goes on. In that case, if SBO provisions are applicable to the holding company and holding company itself is reporting, then that first one company is not again supposed to comply with the SBO rules, because holding company itself is reporting or making compliance with applicable provision of Companies Act. In that case, holding reporting company applicable, then the main company is not required to again comply or submit the form B2. Third, government. Fourth, other institutions controlled by the government. Fourth, SEBI registered investment vehicle or mutual funds. And fourth one is a RBI, RDA like entities. So these are the entities who are not required to comply with the section 90 or not required to submit the Ben2 form or SBO compliances in short. So other than that, where it is applicable, other than OPC, all companies are required to comply with the SBO subject to applicability. In short, all the companies are required to comply with the SBO compliances subject to applicability. So we will go in detail one more step ahead. What is significant beneficial ownership? Before that, I want to go back and discuss about section 89, because point is that majority of the professionals, even qualified company secretaries who are practicing fully in a Companies Act, have confusion about section 89 and section 90. But these both are the different sections and their applicability are different, and reporting criteria and reporting formats are also different. But even though there is a confusion, what section 89 mainly focus on? Reporting of beneficial ownership. There is a owner by this section, ownership of shares are divided in two parts. First one is the register owner, the person whose name is recorded in a register of member as a member of a company by virtue of holding the shares of the company, is known as a member ideally. But the person who is recorded as a member in a register of member of a company for the sake of compliance purpose only, and all the benefits by virtue of holding that shares to be benefited by someone else, the person who is actual benefit getting of corporate actions, such as a company declare a bonus shares, company declare a dividend. So what are the benefits one can have by virtue of holding the shares is getting or benefited by some other person that whose name is registered in the register of member. So here register owner is the one concept, and second is the beneficial ownership. Why this happens? Because as per the provision of Companies Act, even private company other than OPC should have at least two shareholders. Many of the foreign companies come to India for their business. They want to incorporate a wholly owned subsidiary company in India. So how they can incorporate a wholly owned? But they just have a let's assume they have a main company in UK, and they want to start their business in India. So they came to India and incorporated a company. But as per the provision of Companies Act, there must be a minimum two shareholder. So except one share, all shares are held by the UK holding company, and one share will be held by the Indian person. Also, one Indian person must be shareholder as per the Companies Act provision. So one share will be held in a Indian person name. Okay, that Indian person is the registered owner whose name is mentioned in a register of member as a member by virtue of holding securities. But any benefit declared by companies such as a dividend or bonus will be getting by the that UK company, in case that UK company is registered as a beneficial owner. So what are the compliances? Form MGT4 is to be given by registered owner to company in format MGT4 by the registered owner to company. Form MGT5 is the form to be given by the beneficial owner to company, and Form MGT6 to be submitted by the company along with attachment of MGT4 and 5, which has received from the registered owner and beneficial owner respectively, and submit with the MCA form MGT6 in online format. So point here is, here we are discussing the significant beneficial ownership. Section 89 speaks about beneficial ownership only. Beneficial ownership is the something different, and significant beneficial ownership is different. So many of the many times professional interpreting here is that if company is applicable for the reporting under section 89 and required to submit a form MGT4, MGT5 and MGT6, then that company is not applicable to submit form Ben2. But this is not a criteria. Both sections are independent. We have to read them independently and interpret them independently. It is not a scenario that either MGT6 or either Ben2 will be submitted. Both are different. if company is applicable, applicable and required to submit MGT6, company supposed to comply with the same. If company have significant SBO rules applicable, then company is supposed to submit Ben2 form. If company applicable, both the criteria hit the board, company hit the both criteria, company supposed to respectively submit the MGT6 and Ben2. Okay, so this is that was the quick review of the section 89. Now we will come back to the section 90. SBO, significant beneficial ownership in relation to reporting company. Reporting company means company who is supposed to comply with this SBO section and submit the necessary document or declaration with a MCF. The company is supposed to submit the form Ben2. That company is known as a reporting company. So any individual who is acting alone or with together or through one or more person or trust possesses one or more of the following right or entitlement. So anyone or multiple ways, if any person holding rights or entitlement. Now provisions has mother provision has given a power to authority to prescribe the applicability criteria, and in Companies Act provision 25% is criteria mentioned for the significant beneficial ownership, but the authority nowadays what is applicable, 10% is the applicable. So we directly consider as a 10% is the basic criteria, okay, to decide the SBO, whether SBO is applicable or not. For that reason 10% is the that magical number we have to just find out to decide the SBO whether holding is 10% or not. Now holding means what? So we have to identify by 4 criteria. First one, hold shares. That shares may be held directly or indirectly. Directly we know there is a ABC Private Limited and I Vishwanath hold the 12% shares in a ABC Private Limited, but 12% is more than 10%, but does not need to comply with the SBO rules, because being an individual as a Vishwanath, I directly hold the shares of ABC Private Limited. That everyone knows. Vishwanath holds the shares of ABC Private Limited. That is the direct holding. But in case I hold the 8% shares in ABC Private Limited and B Private Limited is a company who holds shares in ABC Private Limited, and again I hold the shares of B Private Limited. So in that case, I have direct holding of shares. Apart from this, I have indirect holding of shares. How indirectly? I hold the shares of B Private Limited and B Private Limited hold shares in ABC Private Limited. So what we have to consider to hit the criteria of 10% is the direct holding of shares. In addition to that, indirect holding of the shares. Both. How indirect holding of the shares will be considered, or we have to find out. We'll go in detail in next slide. But now we have to keep in mind that direct and indirect shares holding hit 10%, then SBO is applicable. Now, even though someone is not holding the shares but holds the voting right, enjoys the voting right, in that case, one can ask how voting right can be enjoyed without holding the shares. It might be possible that company has issued a preference shares or debenture or by virtue of default for continuous mention period that security holder have got the voting rights. So any of this like criteria, voting rights hits 10%, then also voting rights also directly or indirectly. In third case, we have if any person who is receive 10% or more of dividend, and in first one is a holding of 10% share, second one is the voting right, or third one is a dividend. If one has shareholding, voting or dividend of 10% or more, will be SBO is applicable. What fourth point says, has the right to exercise or actual exercise significant influence or control. Now these are the two keywords. Significant influence. What we are studying here is that significant influence. So For that purpose, we read the definition of significant influence and control as well. Okay, so we'll discuss the control and significant influence. If we compare control and significant influence, control has a upper hand, and significant influence is a one step below the control. Point here is section 90 speaks about the significant influence. Point here is section 90 speaks about the significant influence, and if significant influence is there, we have to comply with the SBO rules. Now, kick here is control is a one step ahead. Means wherever there is a control, in head there is a significant influence. If any person have control over any private limited or public limited company, it means that person who have a control is also have a significant influence. Okay, if any person have only significant influence, it does not mean have control, but any person who have control have a significant influence in a company. It means control is not specifically discussed or in detail focused. Everything is around the significant benefits. Everything is around the significant influence. So in that case, even though control is proved, we have to comply with the significant influence. So when the control will be considered as control, means control as defined in section 227 of the act. Act means Companies Act. As per the section 2 subsection 27 of the act, control shall include the right to appoint majority of the directors. If any person have majority directors, right to appoint the majority directors on a board of a company, or to control the management or policy decisions, or exercised by person or persons acting individually or in concert. I'm not going in detail about the individually or acting in concert pack. That definition we are already aware. Directly or indirectly, including by virtue of their shareholders agreement or voting agreement, or in any other manner. So by this way, we can identify whether there is a control or not. Significant influence means power to participate directly or indirectly financial and operating policy decision of reporting company, but is not in a control or joint. So if there is a not control, but there might be possibility of significant influence. How we will identify? By identifying the criteria of 10%. Okay. So till the time we have discussed the importance and started to discuss about the applicability. So we'll move to the next slide. Here we'll try to identify the SBO applicability on the reporting company. Let's assume there is a company who all members are natural person. If there is a let's assume ABC Private Limited is a company who all members are a natural person. If yes, then SBO provisions are not applicable. If all persons are not natural persons, then what are the other possibilities? Whether member are pool investment fund or mutual fund kind of company, in that case again SBO provisions are not applicable. We have specifically discussed that in a non-applicability. If all the shareholders are not natural persons, not individual, and company is not a pool investment vehicle or mutual fund kind of company, if both the answers are no, we move to the third point, whether person other than natural person, in short individual holder, person other than natural person holds 10% or more of shares. Shares includes the CCD compulsory convertible debenture, CCPS compulsory convertible preference shares, and GDR global depository receipt. If other than natural persons holds 10% or more of the shares in a company, if yes, then SBO is applicable. If answer is no, whether person other than natural person exercise significant influence, other than natural person, if influences the significant exercise the significant influence, if yes, again SBO is applicable. If answer is no, whether person other than natural person exercise control, then also SBO is applicable. So first criteria is that if any company have all the individual or natural person as a shareholder, then section 90 is not for that company. SBO provisions are not applicable to the company. Okay. if any company have a body corporate as a shareholder, ultimately that body corporate who is a shareholder in a company may have another body corporate or whatever, but at the end there must be a, at the end of that chain must be a individual person. That individual person is ultimate a significant beneficial owner, and reporting company supposed to comply with or report for that person. Okay. uh, Speed is okay for everyone.
Yes, sir.
Okay, okay. Okay. So we'll move to the next slide, determination of SBO. So in case of only individuals as a shareholder, let's assume ABC Private Limited has only individual shareholders. Then there is no indirect shareholding, as all are the individual shareholders and direct shareholders. In that case, SBO provisions are not applicable and no actions required under section 90. Next, in case of a HUF, Hindu Undivided Family, HUF as a shareholder, it means ABC Private Limited is a company who has a shareholder as a HUF holding shares of a ABC Private Limited. In that case, in case of a HUF, if HUF holds the shares in any company, in that case, the person who is a karta of particular HUF will be treated as a SBO. So we'll discuss here. ABC Private Limited has HUF has one of the shareholder. Whether such an HUF holds more than 10% shareholding in ABC Private Limited. If HUF holding in that ABC Private Limited is more than 10%, then Karta of the HUF will be treated as a significant beneficial owner and required to make the compliance under section 90. If less than 10% holds, in that case, action is not required. SBO is not applicable. Next, LLP firm as a shareholder. First, we have discussed individual as a shareholder. Later on, we have discussed how the HUF. Now we are discussing LLP is a shareholder in a ABC Private Limited. ABC Private Limited has a firm as a shareholder. Whether firm holds more than 10% of shares of ABC Private Limited. If answer is a no, then SBO is not applicable. If that LLP is holding 10% or more shares in ABC Private Limited, the answer is SBO applicable. Point is, who is ultimate significant beneficial owner? In case of a body corporate like LLP, in case of a firm, all the partners of that firm are treated as a SBO, significant beneficial owner. If partner is a body corporate, find an individual holding more than 50% in body corporate B. We are here we have discussed about the one layer. Now this point we are continuing this fourth step. We are continue and adding one more layer of body corporate holding. First, ABC Private Limited, who has the shares held by the one LLP, who holds more than 10% shares in that LLP. Now there is another body corporate who holds more than 50% shares in that LLP, who is holding shares of ABC Private Limited. Whether going up the ladder, first case ABC Private Limited, uh, reporting company. Next step, LLP, who is a shareholder in ABC Private Limited. At the third stage, there is another body corporate, which may be LLP or a company, who is a shareholder in that LLP and holding more than 50% of the LLP. Now, going up to the ladder, you find an individual who holds more than the 50% of SBO. If we the third body corporate who is holding more than 50% in a LLP have individual shareholders who holds more than 50% of that third body corporate. If answer to A, answer to B, and answer to C is yes, then SBO is applicable. If answer to A, B, C is no, then we have to SBO is we do not have SBO applicable. So in that case, SBO compliances are not required. Okay. Next, company or body corporate as a shareholder. ABC Private Limited is a reporting company, has a corporate shareholder. Whether such shareholder has 10% of ABC Private Limited. A step. ABC is a reporting company who has a shareholder holding 10% or more of the shares of ABC Private Limited. If individual shareholder of corporate shareholder holds more than 50%, then he will be SBO. What? ABC has a corporate shareholder, and that corporate shareholder have one individual shareholder who holds more than 50% of that corporate shareholder. In that case, that individual is a SBO, and ABC Private Limited, who is a reporting company, required to comply with the Section 90 SBO compliances, required to submit PEN2 form. If another body corporate is holding 50% in A body corporate, ABC is the first company, has a body corporate shareholder who holds more than 10%, has another body corporate as a shareholder holding more than 50%. Find an individual holding more than 50% of body corporate. Same concept I have explained with an example in next slides also. If we do not have doubt here, I try to present in a diagrammatic way, so we'll have detailed idea over there. Trust as a shareholder. ABC Private Limited has the trust as the shareholder. In that case, we have to check that whether trust holds 10% or more of the shares of ABC Private Limited. If answer is yes, trust is holding 10% or more shares in ABC Private Limited. In that case, trustee of a trustee of discretionary trust or charitable trust, a beneficiary of a specific trust, and author or settler in case of a revocable trust is an SBO. So here given that what are the types of trust and particular category of trust in case to case kind of category of trust, and who is the SBO in that category of trust. So if answer is no, then SBO is not applicable. But if answer is yes and holding more than 10%, so we have the trustee or author settler will be treated as SBO depend upon the category of the trust. Okay. Now onwards, we'll discuss the illustration. So we'll have a better idea about the applicability, because point is that just 27 October notification we have discussed. That notification has not only says that the dematerialization of shares, it also says that every company who is non-small, annual filing form MGT7 to be submitted with MCA. That form MGT7 is modified, and what they are additional information asking in form MGT7, every company is supposed to authorize a person or designate a person who is responsible to check the criteria of SBO applicable or not. Every company. So what it means, many times earlier what it happens, there are many cases SBO is applicable, but no one is aware. No one is aware about the SBO applicability, and there is no compliance because no one is aware. Neither company secretary, neither directors, neither promoters, and no one. So what government wants to report name of a person as an authorized person who is responsible in a company for the reporting of SBO. Means in case of a default of SBO provision, किसी को एक को बलि का बकरा बनाना है, क्योंकि अगर गवर्नमेंट को डांटना है, पेनल्टी लगाना है, एक्शन लेना है किसी के आगे, तो एक बंदा स्पेसिफाई करना है. अब जिसका नाम जाएगा वो क्या करेगा, फिर स्ट्रिक्टली चेक करेगा. अगर किसी का नाम डेजिग्नेट किया है कंपनी ने, तो that person will 100% sure whether SBO is applicable or not. If yes, he makes sure that compliances are made. Otherwise, he'll resign from that designation or authority. Okay, so that is the important thing. So point here is that scenario is changing very fast day by day. This is not the same that we are operating the corporate 2-3 years back, and we will operate the same way in upcoming 2-3 years down the line. Once September 24 is passed on, companies will be taken a strict action. If any company found by the government SBO is applicable and company is not aware or not reporting, the serious penalties or notices will be issued, and it is not avoidable, or one cannot neglect the things. So these are the very much important. So we'll discuss in detail. P1 holds 20% shares directly in RC. RC stands for reporting company. So we are considering ABC Private Limited is the main company. We have to understanding the concept from the RC reporting company point of view in all the examples. So P1 is the one shareholder who holds 20% of shares in reporting company directly, individual shareholder. P is the person one individual shareholder. So there is no indirect holding. So point here is to decide the SBO in simple language, there must be a 10% of holding or more than that, and there must be an indirect holding. If direct holding more than 10%, there is no SBO compliances. SBO compliances will be applicable in case of indirect holding and 10% criteria. If anyone have a holding indirect or direct both combination, then also compliance of SBO are applicable. P1 holds 20% holding directly in RC. As the holding is directly, SBO compliances are not applicable. So no SBO declaration is required. As SBO compliances are not required, declaration under SBO is not required. Illustration number second. We are improving the deepness or toughness of illustration step by step, so one can have a better understanding, because in a practically in corporate this kind of holding structures are in a place, and it is very confusing to identify whether SBO is applicable or not. Just for the assignment purpose or just for the fun purpose, one can identify the we have two companies listed on Indian Stock Exchange, NSE and BSE. First one is the Adani Group company and second one is a Vedanta company. If we decided to find out who is the ultimate owner of the Vedanta company, so there is a very complex holding structure, because Vedanta India or let's assume Vedanta UK is a holding company. Then Vedanta UK has another country company who is holding of that UK company. And ultimately, after the 4, 5, 6 layers, we found that one company on Iceland, which is tax haven island, and that company is registered on that island, which is a very small geographically. So practically it happens. So that's why it's more important. So we'll continue with illustration number 2. Person 1 holding 20% in reporting company and more than 50% in H1 company. Reporting company P1 directly holds 20% in a reporting company. And now H1 is the holding company who H1 is the one company who holds only 1% shares in a reporting company. Only 1% shares. And P1 is a person who holds more than 50% shares. Who holds more than 50% shares in a H1 company. Now what happened? P1 have a 20% shareholding in a direct route and 1% shares held by the H1, and P1 holds more than 50% shares of H1, means P1 have a control on H1. So indirectly P1 is holding indirectly 1% in RC in addition to the 20%. Now indirect holding is there, and total holding 20% plus 1% is 21%, which is more than 10%. Then SBO is applicable. Okay. Third illustration number third. P1 person 1 and person 2 are holding 8% and 5% in RC. Both are individual shareholders, P1 and P2, and directly holding their shares in a reporting company. Unless there are indirect holdings, there is no case for SBO declaration. Let's assume P1 and P2 are husband-wife. They are related party, person acting in concert. But even though P1 name and P2 name are directly in a list of shareholders' name, it means they both are holding reporting company shares in a direct route. So whenever holding is only in a direct route, SBO provisions are not applicable. Okay. So there must be a indirect holding and there must be a more than 10% holding, whether it is individually or holding directly or indirectly, or there must be along with the person acting in concert. So P1 and P2 holding, even though they are in a person in concert, they are individual and direct owner. So SBO declaration is not applicable. Illustration number 4. P1 directly holding 8% in reporting company. P1 is a person, one is an individual who holds 8% shares in a reporting company. Okay. P1 is a beneficiary in trust. We have discussed here that if trust is holding more than 10%, trustee of the discretionary category trust will be treated as a SBO. Okay. So here point is trust is holding 5% and individual directly holding 8%. 5 plus 8 is a 13%. But point here is that P1 directly holding 8% in reporting company. P1 is a beneficiary in trust. Trust is holding 5% in a reporting company. The trust has made a declaration under section 89. We just while starting with the session had a recap of section 89. So what it says about the registered owner and beneficial owner and compliance on that part is in duty 4, 5, 6. So what says that trustee who is a P1 is a trustee who what he did made a declaration under section 89 and says that I am the beneficial owner of the 5% shares held by trust in reporting company. And company reporting company knows that P1 holds directly 8% and trust holds 5% and trustee of that trust is P1 only. But what P1 has made a declaration under section 89 that I am the beneficial owner. If company declares a dividend, reporting company, ultimately P1 is getting. If company declare a bonus shares, ultimately P1 is getting. What we have lifting of corporate will is a one concept in a company's act that trust is the registered owner, but who actually gets benefit? Trustee. So in that case, SBO is surprisingly not applicable because section 89 is applicable and P1 has made a declaration under section 89 and says I am the direct beneficial owner. What impact of section 89 brings here is that P1 says I am the direct owner. We have categorized ownership of shares in two parts, registered owner and beneficial. So by the compliance of MGT 6, P1 says I am the direct owner. It means 8% hold by P1 is direct holding and 5% hold by also direct holding because 89 compliance is done by the P1. So 8% holding and 5% both are 13%, more than 10%, but both holdings are in this specific case are direct holdings, so SBO compliances are not applicable. Okay, next illustration we are moving. Just 1 minute. Illustration number 5. P1 is holding 8% in reporting company, direct shareholding. P1 is the individual who holds 8% shares in reporting company. P1 is the Karta of HUF. There is one HUF who holds 5% shares in a reporting company, and P1 is a Karta of that HUF. P1 is Karta of that HUF. So in this case, we already discussed that if HUF is a holding shares, Karta of that HUF will be treated as the SBO, and total holding percentage if more than 10%, then SBO is applicable. Okay, so direct holding of 8% and indirect through HUF holding is a 5%. In total, they are holding a 13% of shares. So P1 is a SBO treated and compliances of SBO are required to be complied with. Okay. Illustration number 6. Computing indirect holding. P1 is directly holds 1% in reporting company. P1 is directly holds 1% in reporting company. What? P1 and here is the reporting company. P1 directly holds 1% share. It means list of shareholder of reporting company have name of P1 for the holding of 1% shares. Okay. Now H1 is the another company who holds 10% shares in a reporting company, and P1 who holds more than 50% shares in H1. Means P1 have control on H1. Okay. So what indirectly P1 holding 10% shares in reporting company and directly holding 1%. It means in total 11%, which is more than 10%, and direct shareholding as well as indirect shareholding of 10% is there in the hands of P1. So in that case, indirect holding is there and more than 10% holding is there. Okay. So require SBO provisions are applicable and required to comply with. Okay, let's continue with applicability. Later on, we'll discuss with the compliance. Compliance is not a tricky. Applicability is the more important. Okay, we just have discussed with this illustration. Illustration number 7. Same again. P1 is the one individual who holds directly 1% shares in a reporting company. H1 is a company who holds 10% shares in a reporting company. H2 is a company who holds 60% shares in H1. What it means? H2 company is a holding company of H1 company. H2 company is a holding company of H1 company by holding 60% shares. Again, H3 company holds 60% shares in a H2 company. Again, H3 is a holding of H2. H2 is a holding of H1. Okay. And P1 holds 51%, which is more than 50% in H3. Okay. Reporting company, H1 holds 10% shares in reporting. H2 holds 60% shares in a H1. H3 holds 60% shares in a H2. And P1, who is an individual person, holds 51% shares in a H3. It means that 10% shares held by H1 are indirectly actually held by P1 in reporting company. So indirect holding of 10% of P1 will be assumed in a reporting company, and direct shareholding of 1%, which is more than 10%, and indirect shareholding also reflecting there. So in this case also SBO provisions are applicable. Illustration number 8. So P1 is an individual. Reporting company have a 3 shareholder, or let's assume H4 33, 33, 33, or 31% into total 100%. So focus on H1. H1 is a company who holds 33% shareholding in a reporting company, and P1 who holds 51% shares in a H1 company. It means holding up more than 50% shares means having a control. We just seen the definition of control. If one person have a 51% shareholding in a company, he can take the decisions, he can appoint the majority directors, or in short, he have a control on a company. So P1 have a control on H1, and H1 is holding 33% shares in a reporting company. It means these 33% shares held by H1 are indirectly held by P1 in reporting company. What it means? 33 is more than 10% and P1 have indirect shareholding in a reporting company means SBO provisions are applicable. Illustration number 9. A reporting company have 3-4 shareholders. We continue. H1 is the company who holds 33% shares in a reporting company. Who holds 33% shares in a reporting company. Another company named H4 who holds 33% shares in a H1. Point here is that 33% is less than 50%. It means that chain of control is breaking here. So H1 holding 33% shares in a H1, it does not mean H1 do not have control on H1. If H1 and P1 holding 51%, even though P1 have control on H4, but H4 do not have control on H1 due to holding of 33%, which is less than 50%. Okay, so in this case, chain breaking here. Chain breaks here, and uh, holding of 33% in reporting company by H1 company is not treated as a holding of P1, and P1 for the purview of P1, SBO provisions are not applicable. SBO provisions are not applicable. Okay, but let's assume there is some P2 person who have 51% shareholding in a H4 company. It means that person who have more than 50% shareholding in H4 have indirectly control on H1 who holds 33% shares. That P1 can be on P1 SBO is supposed to be applicable, but in P1 is not, because by holding 33%, which is less than 50%, chain of that control is breaking, and holding of 33% by H1 in RC is not treated as a holding of P1. So SBO is not applicable in this scenario. Illustration number 10. P1 is an individual person, is a SBO. H1 have a subsidiary of H2, and H2 have a subsidiary is H3. Now P1 is already a declared SBO of P1 is already a declared SBO for H1. Here already a declaration that H1 P1 is a SBO for H1 by virtue of holding. In that case, Rule 8b provides that the shares held by the holding company shall be excluded from the applicability of this rule. However, the details of such shall be reported in Ben 2. What Rule 8b says that shares held by holding company. Now, let's assume H2 is a subsidiary of H1 and H3 is a subsidiary of H2. What it means? H2 is a holding of H3 and H1 is a holding of H2. So in this case, what Rule 8b says that the shares held by holding company shall be excluded from the applicability of these rules. While calculating the applicability, we have to exclude, but while reporting once the SBO is applicable, we are reporting the compliance in Ben 2 form. While submitting or reporting the Ben 2, we consider these details. So no SBO declared is required for H2 and H3, but in case of H1, P1 is the SBO that is already declared in the examination. Example illustration, but for the point of view of H2 and H3, there is a no SBO compliance, because ultimate holding company, we have seen in non-applicability first that reporting ultimate holding company is a reporting company. So in that case, subsidiary company do not require to comply again. So that is the example illustration number 10. Next illustration number 11. Since P1 since P1 is not holding majority at either at H1, P1 holds majority in H2. P1 holds majority shares in H2 company, and H2 holds 40% shares in H company, and H1 holds 10% shares in a H3 company, and H1 also holds 10% in reporting company. In addition to that, P1, who is individual shareholders, holds 20% shares directly in a reporting company. Since P1 is not holding majority at either at H1, why? Because H2 is holding only 40%, which is less than 50%. Okay, hence not majority means P1 is not holding majority in H1 because H2 holding less than 50%, which is 40%. H1 or ultimate holding company of H1 is not the holding company of H1. The holding of H1 will not matter at H1 level. The holding of H2 is the indirect holding of P1 at H1 level. At this H1 level, the holding of H2 is the indirect holding of P1. Yes, whatever the shares held by H2 in H1 will be the indirectly considered as a hold by the P1 because P1 holds majority shares in H2. Yes. but that next layer will not be continue because of that 40% shares. Means whatever the shares held by H1 in H3 will not be considered as hold by P1 because of this chain is control chain is breaking here. But whatever the shares held by H2 in H1 will be considered as an indirect shareholding of P1 in H1 by virtue of majority holding of P1 in H2. Hence, P1 is the SBO for H1. So, if we look at this triangle, P1 indirectly holds 40% shares in H1 because P1 holds majority in H2. So, for H1, SBO provisions are applicable. For H1, SBO provisions are applicable, but not for the holding in H3. So SBO declaration not required for a reporting company. Again, because even though uh, uh, P1 have direct shareholding of 20%, we do not be considered. It is do not be considered as P1 have indirect shareholding in reporting company because chain breaking here. Holding of 40% is less than 50% and it does not fulfill the criteria of control. If control is not there, significant beneficial interest is significant influence will not be there. Okay. So H1 yes H1 have to comply with SBO compliances for P1 holding, but reporting company SBO compliances are not applicable, and even H3 also SBO compliances are not applicable. So SBO declaration not required for reporting company. It will be required at H1, not required for H2 and H3. SBO compliances are applicable for H1 and not for the H3 and reporting company. And H3 and reporting company not applicable. H1 at the level of H1, SBO compliances are there. Hope everyone have a clear idea about, because a lot of confusion and tricky examples are there. Actually section is this much tricky. Okay, we have last illustration, number 12. P1 P1 is an individual who holds direct 8% shares in a reporting company. Okay, and trust also have 5% shareholding in a reporting company. What happened in this case? If the trust is discretionary trust, public trust, P1 is a trustee. P1 is holding 8% in reporting company. Since P1 is a trustee, trust holding will be the indirect holding of P1. Hence, SBO declaration is required. Provided that we earlier discussed that under section 89 compliances are not made. If made, that considered as a direct holding. If not made, because earlier we have discussed about the here we are discussing about the discretionary trust. So in this case, SBO declarations are required because 8 plus 5 are 13%, which is more than 10%, and P1 is the trustee, which is considered as an indirect holding and reporting company. So in this case, SBO declarations are required. So these are the examples. So once by uh, having all this discussion, hope so कि we can find out whether the SBO is applicable to company or not. Once we at a conclusion that SBO is applicable, once we are at a conclusion that SBO is applicable, then we'll move forward and start with the end uh, chapter of our session, that what are the compliances. Once we find out that SBO is applicable, what compliances company supposed to do, reporting company supposed to do. So compliances first, there are three BEN forms we should consider as important. First one is a BEN 1 form, second one is a BEN 2 form, and third one is a BEN 3 form. BEN 3 form is a register. We just have to maintain a register at a register office where we note down all the SBO details. Okay, so this BEN 3 is a register format. We have to maintain a records. in Ben 3. Ben 1 is the declaration by the individual. Let's assume for the better understanding, this is the section 2. P1 holds 20% in a reporting company, and H1 hold 1% and P1 hold more than 50. So SBO is applicable. So in this case, Ben 1 form is a declaration. BEN, Ben 1 form is the declaration supposed to be given by P1 individual to reporting company, and reporting company is supposed to submit form Ben 2 with MCA. P1, who is actual significant beneficial owner, supposed to give Ben 1 declaration to reporting company, and reporting company is supposed to submit form Ben 2 with MCA. Now, what is the timeline or what is the due date for this submission? So let's assume today P1 has purchased 20% shares in a reporting company. We assume that 1% holding of H1 is already there, and P1 holding more than 50% in H1 is pre-existing shareholding. And today on 4th of November 2023, P1 purchased 20% shares of reporting company. So in this case, the relationship of significant beneficial ownership arises today, because P1 knows he is holding already more than 50% in H1, and H1 hold 1% in reporting company. Now indirect shareholding is there, and 1% plus today's buying of 20% is more than 10%. So P1 knows the relation arises on 4th of November. P1 have time limit of 30 days, 30 days to submit declaration in form Ben 1 to reporting company. Means within assuming 30 days month, before the 3rd of December, P1 supposed to give Ben 1 form declaration to reporting company before 3rd of December. Now, once the reporting company received the declaration in Ben 1 form from the SBO, the reporting company is supposed to submit the same. Reporting company submit the same in Ben 2 form. In Ben 2 form with MCA from within next 30 days. 30 days from the day on which reporting company received the declaration in Ben 1 form from the SBO. So let's assume he received on 1st of December. Supposed to P1 supposed to submit Ben 1 to reporting company before 3rd of December. So he submit on 1st December. So within 30 days, means before 30 December 2023, reporting company is supposed to submit the form Ben 2 with a MCA. So normally what happens, any form like ITR due date is the standard due date for that all class of companies or individuals or assessees, whatever we say, like private company ROC compliance due date or DIN KYC due date. We have standard date as a due date, but for the Ben compliances, for the SBO compliances, there is a no standard due date. It depend upon the date of transaction or relation arises, or so for the reporting company purpose, 30 days from the receipt of declaration in Ben 1 from the SBO, reporting company is supposed to Ben 2 with MCA. Okay, so responsibility of SBO. The point is SBO supposed to give declaration in Ben 1 form within 30 days from the acquisition of shares, and it is the responsibility of that individual SBO. Once SBO give Ben 1 declaration to reporting company will submit Ben 2. Upon declaration return of SBO, upon declaration, the reporting company shall file a return in form Ben 2 with the registrar, means ROC MCA, in respect of such declaration within 30 days from the date of receipt of declaration. Okay, and register of SBO will be maintained in form Ben 2. The point here is that, sir, it's okay that Ben 1 to be submitted by individual. Let's assume we have a ABC India Private Limited. We have a ABC India Private Limited, and ABC India Private Limited have a holding company in a USA holding company, and that USA holding company has Mr. Brent is the one individual who is a shareholder. In that case, SBO is applicable. Now what happens? Indian company is the reporting company, as there is a corporate body corporate shareholder, and that body corporate have an individual shareholder. Ultimately, that individual is the, have a significant beneficial ownership in a Indian company ABC Limited. So in that case, reporting company is Indian company. Company is supposed to comply with MCA. Point here is that whatever Mr. Brent, who is an American citizen, is not aware or not serious about the compliances of the Indian Companies Act. So what is the fault of reporting company? Because ultimately Indian government or Indian authorities will leave the penalty or make defaulting declaration of an Indian company. So what are the consequences, or what are the measures being an Indian company has been provided by the law? So point here is that even when one declaration to be submitted, even though that person is not an Indian, supposed to follow Indian laws, and his responsibility to be given Ben1 declaration within 30 days from the acquisition of shares. So point here is that he is not aware being a citizen of USA. So reporting companies are supposed to inform him and ask him, provide a format and fill in the blanks and sign and provide us it back. So we can proceed further with the Section 90 compliances of Companies Act. Point here is that he says, I'm not interested, I'm not giving, whatever be the reason. I don't want to disclose my holding. So in that case, Indian company supposed to give notice in form Ben 4, and even though after within specified time limit, that individual person who is a USA citizen not providing declaration in Ben 1 or necessary information to the Indian reporting company, Indian reporting company can approach to tribunal. Tribunal means NCLT, National Company Law Tribunal. So Indian reporting company can approach or apply tribunal against whom? That USA citizen. A point is, it is okay to theoretically read and discuss and interpret, but let's understand how practically it will work. Let's assume there is an Indian company whose holding company is in USA. What it means? USA is funding, or FDI is there to run the business in India, and that USA holding company must be, there is a natural person who is behind that company. So that individual is the ultimate owner of Indian company also. Okay. So how Indian company can take or go against the USA citizen who is the ultimate owner of the Indian holding company? Indian company have holding company in USA, and USA is the individual shareholder who is the owner of that USA company, and USA company is the holding of Indian company. So how practically it will work is absolutely doubtful, but provisions are made, and there are some kind of exception that management disputes are there. So but obviously management of an Indian company go against that individual in abroad or foreign, and approach or apply to tribunal, but in normal parlance it will not digestible. सो इन शॉर्ट एसबीओ अगर नहीं देता है इंडिविजुअल जो है, तो रिपोर्टिंग कंपनी कैन अप्लाई टू ट्राइब्यूनल. हाँ, now the latest amendment we already discussed that in form MGT 7, every company what needs to do, name the person or designate a person who is a designation of a person as a beneficial owner officer. So in form MGT 7, every company what needs to do, designate one person in a company who is the beneficial owner officer. It means company attracts at any point of time the provision of Section 90 in a company, and if company fails to comply with the Section 90, that beneficial owner officer will be first person who will be catched by the authorities. Okay, who is the officer is the first person who will be penalized on priority basis because his name is designated in a form. So as per the recent amendment to the SBO provision, every company shall appoint an individual under this rule who will be responsible for providing information and cooperating with the registrar or any other authorized officer regarding beneficial interest in the company shares. Such person shall be appointed by passing a board resolution. So आसान भाषा में क्या बोला है कि कंपनी, हर एक कंपनी को अपने MJT 7 फॉर्म जो एनुअल रिटर्न, उसमें कंपनी के बोर्ड ऑफ डायरेक्टर का मीटिंग होगा, उसमें बोर्ड रेजोल्यूशन पास होगा और ये पर्सन जो रहेगा उसे डेजिग्नेट किया जाएगा एज अ बेनिफिशियल ओनर ऑफिसर, और उस ऑफिसर का नाम ऑलरेडी क्या करना है, एमसीए को इन्फॉर्म करना है। अगर और उसका काम क्या है, जब भी एसबीओ अप्लाई होगा तो उसे कंपनी को बताना है अप्लाई हुआ है और जो सेक्शन 90 के कंप्लायंसेस है वो कर दें कंप्लीट। अगर अथॉरिटी को नाम दे के रखा है कि ये बेनिफिशियल ओनर ऑफिसर है, इन फ्यूचर कभी भी अप्लाई हुआ था एसबीओ और कंपनी ने कंप्लाई नहीं किया था, तो सबसे पहले उसी को पकड़ेंगे, अथॉरिटीज क्या करेंगे, उसी को पकड़ेंगे। तो ये बलि का बकरा पकड़ के रखा है। तो इससे क्या होगा, जिस पर्सन को डेजिग्नेट किया जा रहा है वो तो 100% श्योर करेगा ना, एसबीओ तो सिग्निफिकेंट बेनिफिशियल ओनर कोई और है और उसका पेनल्टी मैं क्यों भुगतूं, तो वो श्योर करेगा अगर एप्लीकेबल है तो वही रिपोर्टिंग करो, तुम मनी लॉन्ड्रिंग करो, इधर का पैसा उधर घुमाओ, होल्डिंग अल्टरनेट करो, कुछ भी करो, अपने ऊपर नहीं लेगा अगर कोई एक पर्सन का नाम डेजिग्नेट किया जाएगा तो। अब ये जो डेजिग्नेट वाला पर्सन है वो कोई नॉर्मल पर्सन नहीं होगा ना, टॉप मैनेजमेंट वाला ही होगा, या तो डायरेक्टर होगा या तो सेम तो टॉप मैनेजमेंट का पर्सन होगा। तो वो हम देखते हैं कि कौन पर्सन हु कैन बी डेजिग्नेटेड फॉर सच पोस्ट एज अ सिग्निफिकेंट owner officer who can be designated as company secretary if full time company secretary is there in a company. A KMP, now we have a definition of KMP. If company do not if company secretary is there in employment in the company, then CS is the designated officer. If CS is not there in a company then KMP, again the definition of KMP, who are covered in a KMP, CEO, CFO and all that top management directors are covered in a KMP. In absence of a CS, KMP, anyone from the KMP will be designated. In absence of KMP also, every director, not at least 2 director will be there in even a private limited company. So every director when there is no CS and no KMP. So CS or KMP or is director, at least out of this management, top management people, company designate one person as a officer. Details of such person shall be provided in annual written form MGT 7. Every year company क्या करती है, एमसी के साथ एनुअल रिटर्न कंप्लायंस करती है, तो फॉर दैट MGT 7 is the form. So form is modified and we have to report the name of that designated person. Now what if normally what happen, companies submit annual report in MGT 7 on annual basis, once in a year company submit MGT 7. It might be possible company submitted MGT 7 and designate Mr. A's name. It might be possible after 2 months Mr. A tender his resignation in a company. So what in this case? So in this case, company do not need to wait till the next year for next 10 months to submit the name of another person. Company immediately, if any changes in a person who is designated, submit form GNL2 with a registrar. Okay. So normally MGT 7, if any changes in a person who is a designated as an officer, so for that officer GNL2 is supposed to be filed. We have already discussed. Actually, this slide speaks about the MGT 4, 5, and 6. Actually, this is about the section 89 and not about the section 90. But it is very much important. One should have a clear understanding of section 89. Without that, one cannot have clear understanding of section 90. So this is every company, or this is the crux of the notification dated 27th of October 23. Every company other than small company as on 31st March 23 ensure that company has demat. जो भी कंपनी 31 मार्च 2023 के दिन नॉन स्मॉल कंपनी थी, नॉन स्मॉल मतलब जिसका पेड अप कैपिटल 4 करोड़ से ज्यादा था या टर्नओवर 40 करोड़ से ज्यादा था, ठीक है, तो इनमें से कोई भी एक क्राइटेरिया हिट हो जाता है, वो कंपनी स्मॉल कंपनी नहीं रहती है. ही सीजेस टू बी स्टेटस ऑफ स्मॉल कंपनी. वंस द कंपनी इज डिक्लेयर्ड एज अ नॉन स्मॉल कंपनी, इन दैट केस कंपनी को क्या इंश्योर करना है, ISIN नंबर लेना है. ओके. नॉट ISIN क्या होता है, हर एक कंपनी जब भी अपनी सिक्योरिटीज डिमेटलाइज करती है, तो हमारे यहाँ पे दो डिपॉजिटरीज है. हम डिमेटलाइज करते शेयर्स तो या तो CDSL के पास जाएंगे या फिर NSDL के पास जाएंगे. तो वो हमें ISIN नंबर इशू करते हैं और उसके अगेंस्ट वो डिमेटलाइज करते हैं. व्हाट डिमेटलाइज मीन्स, जैसे हम पैसे बैंक अकाउंट में रखते हैं, तो हम फोन पे देख सकते हैं हमारे बैंक में बैलेंस कितना है. लेट्स अज्यूम 100 रुपीज बैलेंस है, तो 100 रुपीज रिफ्लेक्ट हो रहा है वहां पे. मतलब एक्चुअल में भी हम इसे 100 का नोट बना सकते हैं चाहे तो विड्रॉ करके, बराबर. सेम उसी तरीके से डीमैट फॉर्म में हम शेयर्स रख रहे हैं. सॉरी. अब क्या होगा, कोई नॉन स्मॉल कंपनी और नॉन स्मॉल कंपनी के शेयर्स जैसे मान लो 10% है, वो डिमेटलाइज करेंगे. मतलब मान लो उनका जो भी डीमैट अकाउंट है उसमें उन्होंने रिलायंस के शेयर्स लिए, HDFC बैंक के लिए, और इनका ABC प्राइवेट लिमिटेड कंपनी, इसके शेयर्स जब वो डिमेटलाइज करेंगे, तो जैसे उनके डीमैट अकाउंट में HDFC और रिलायंस के शेयर्स दिख रहे हैं, वैसे ही उनके डीमैट अकाउंट में उनके ABC प्राइवेट लिमिटेड के शेयर्स दिखेंगे. बट पॉइंट ये रहेगा कि इनके ABC प्राइवेट लिमिटेड के शेयर्स सिर्फ डिमेटेरियलाइज है, स्टॉक एक्सचेंजेस पे लिस्टेड नहीं है, तो वो ट्रेड बाय सेल नहीं हो पाएगा डीमैट अकाउंट से, बट वो दिखेंगे वहां पे डिमेटेरियलाइज होने की वजह से. HDFC क्या है, डिमेटेरियलाइज भी है और लिस्टेड भी है. इनकी ABC क्या होगी, सिर्फ डिमेटेरियलाइज होगी, लिस्टेड नहीं होगी. तो डीमैट में शेयर दिखेंगे बट वो ट्रांसफर या बाय सेल नहीं किए जा सकते, डीमैट अकाउंट का यूज कर सकते. तो फर्स्ट वन इज ISIN नंबर ऑप्ट करना है. लेटर ऑन ड्यू डेट क्या दिया है, 30 मार्च के दिन जो भी नॉन स्मॉल कंपनीज था उनको 18 मंथ्स का टाइम दिया है. मतलब 30 सितंबर 24 के पहले क्या करना है, कंप्लाई करना है. अगेन वंस नॉट टू इशू शेयर्स, अभी मान लो कि ये तो ड्यू डेट है कि 30 सितंबर 24 के पहले करना है. मान लो कोई कंपनी है जिसको दिसंबर 23 में शेयर्स इशू करने हैं, कोई नॉन स्मॉल कंपनी जो 31 मार्च 23 को नॉन स्मॉल थी, और आप भी मान लो नवंबर इसी मंथ में अगले मंथ में क्या करना है, नए शेयर्स इशू करना है. तो कोई भी नॉन स्मॉल कंपनी आज के बाद ही 27 अक्टूबर के बाद ही कोई भी नए शेयर्स इशू नहीं कर सकती. अगर उसे नए शेयर्स इशू करने तो उसके पहले अपने प्रोमोटर के और डायरेक्टर के शेयर्स डिमेटेरियलाइज करके लेने पड़ेंगे. In addition to that, Pass 6 is the return or audit form of dematerialized shares. So half yearly every 6 month, मतलब 1 अप्रैल टू 30 सितंबर के लिए 30 नवंबर का ड्यू डेट आएगा, 60 डेज फ्रॉम द एंड ऑफ हाफ ईयर. एंड फॉर 1 अक्टूबर टू 31 मार्च के लिए अप्रैल और मई 29 या 30 मई का ड्यू डेट आएगा, 60 डेज फ्रॉम द एंड ऑफ हाफ ईयर. तो पास 6 में हमें जब भी हम ISIN नंबर ऑप्ट करेंगे ना, तो उसके बाद जो भी हाफ ईयर कंप्लीट होगा, ईच हाफ ईयर के लिए हमें पास 6 फॉर्म में क्या करना है, रिपोर्टिंग करना है within 60 days from the end of that half year period. और ये जो डिमेटेरियलाइजेशन के प्रोविजंस है, ये पहले निधि को एग्जाम थे. अब निधि कंपनी एज वेल एज जो होली ओन सब्सिडरी कंपनीज है, मान लो कोई कंपनी स्मॉल कंपनी नहीं, स्मॉल कंपनी है, मतलब उसका कैपिटल भी 4 करोड़ से कम है और टर्नओवर भी 40 करोड़ से कम है. इवन इन दैट केस इफ दैट कंपनी तो होली ओन सब्सिडरी कंपनी, सो व्हाट स्मॉल कंपनी का डेफिनेशन होल्डिंग सब्सिडरी कंपनी को स्मॉल कंपनी के डेफिनेशन में कवर नहीं करता. तो जो भी होल्डी ओन सब्सिडरी कंपनीज है, निधि कंपनीज है, सेक्शन 8 कंपनीज है, और सेक्शन 8 भले ही छोटी क्यों ना हो, भले 2 लाख का टर्नओवर था और 1 लाख का पेड अप कैपिटल, बट सेक्शन 8 है तो कंपलसरी उनको क्या करना है, डिमेटेरियलाइज करना है शेयर. फॉरेन सब्सिडरीज है तो इन सबको क्या करना है, ये नोटिफिकेशन के साथ कंप्लायंस करने हैं, अपने शेयर्स डिमेटेरियलाइज करने. एंड व्हाट इज द टाइम लिमिट, 30 सितंबर 24 is the end date, due date. But if any company wishes to do any corporate action like issue of new shares or transfer of shares, so in this case no such action will be taken place until that non-small company makes the dematerialization of promoter and director shares. So here is we end with the discussion, and we'll go ahead with a question and answer. Hope I have tried my best, and you will be have little more idea at a time when we have started and at the end of the session. So hello.
Hello. Okay,
Hi,
sir.
yes. Hi, yes, sir.
My audio.
Actually, sir, voice
Okay.
is breaking. Please repeat, sir. Your voice is breaking.
Hello, sir.
Hi, yes.
Hello. I request all the participants, please. If anybody have question, please ask.
Okay. What science, sir? I have already shared the PPT with Vikas, sir. So if anyone needs, you can circulate freely.
Okay, sir.
Yes, sir.
Any question from anybody? If anybody is having doubt or want to ask something, please.
Hello, Kote sir.
Hi, yes. Yes, sir.
I think nobody have question. So can we go for vote of thanks?
Yeah, sure, sir.
Yeah. Thank you. Uh, so I would like to express my gratitude to all the participants who presents here today. I also extend my gratitude to our honor eminent speaker CS Vishwanath Kote sir for giving his time and nice presentation and sharing his knowledge to all of us. Thank you, sir. Thank you very much.
Thank you, sir. Thanks for the invitation.
Thank you, Vishwanath ji.
Thank you, sir.
Yeah. Thank you, sir. Thank you, Vatsayan sir.
Good night to everybody.
Good night. Yeah. Good night, sir.